Hello and welcome. In today's programme, we're going to look at 4 classic law cases, all of which have had a dramatic impact on the construction industry. I'm delighted to say that joining me in the studio to discuss those cases is construction law expert Roger Knowles. Roger, welcome. Thanks for joining us.
Thank you.
So let's look at our first case.
Well, Morris Cleaners versus Thomas Henwood Hicks was heard in 1966, and it deals with an architect's duty to his or her client. Now, although it's relatively old, it remains a key case and is often referred to in more recent cases. It centres on the debate as to whether an architect can delegate any part of the design to a third party.
So, Roger, take us through the bones of the case and explain why it's still important today.
Well, Morris Cleaners, as the name suggests, are involved in dry cleaning and laundries. They wanted an extension constructed to their laundry, and so they appointed an architect. A contractor was appointed in due course and the work was completed, but unfortunately there were major problems. There were large cracks in the external walls and the purlins began to sag.
OK. And what was the significance of this?
Well, it was a design fault.
Right.
And so the employer put the architect in the frame and said, well, it's your liability. But the architect said, well, when I was appointed, it was implied in the appointment that I could arrange for the contractor to undertake the design work. The contractor undertook the design work and it's his fault, not mine.
Right. And the significance then is that the architect can still be responsible even if he's farmed work out to other people.
Well, the court said the appointment for the design was with you, Mr. Architect, and therefore if there's anything wrong, it's your responsibility. Now, in common commercial world, of course, architects don't design all of the project. They have specialists to design parts of the works, like the piling is done by subcontractors and they have the mechanical electrical designed by a subcontractor there, and perhaps they have a subconsultant that will design other parts of the work. So they stand as the responsible party if anything goes wrong.
Right. And is there any way that architects can avoid this potential liability then?
Well, it's a very simple method which all architects are aware of, and that's to arrange with the employer when the architect is appointed to have the employer agree that parts of the work will be designed by others. But it's essential that that agreement is reached when the contract is entered into. Once that agreement is in place, then the architect can, of course, delegate the work to others.
Yes. What about an architect, say, avoiding liability by expressly saying that they haven't approved the subcontractor's drawings? Well,
that doesn't really make any difference. If the contract is for the architect to design all of the work, then that's his responsibility. The fact that he hasn't in fact approved the drawings doesn't change that one iota.
Right. So has this then resulted in a wave of collateral warranties being signed by various different elements in the construction team?
Well, the answer to that is a straight yes. The idea of the collateral warranty is that some design work might be undertaken, for example, by a subcontractor undertaking the M&E installation, and there's no contract between the employer and the subcontractor. Hence, if the subcontractor perhaps doesn't do a good job with the design, and there's an additional cost to the employer, there's no way the employer can sue the subcontractor direct. So at the outset, the subcontractor is required to enter into a collateral warranty with the employer under which he undertakes to either design using reasonable skill and care or designing a product which is fit for its purpose. If there's a breach of that undertaking, then the employer can sue this subcontractor direct, and that's the purpose of a collateral warranty.
Our second case is Aluminium Industry and Ramalpa. It took place in 1976 and was heard in the Court of Appeal. Again, although a while ago and relatively old, it's a classic that, as we shall see, even had a clause named after it.
Well, Roger, tell us a little bit more about Aluminium Industry and Ramalpa.
Well, Aluminium Industry, they had a contract with Ramalpa to supply aluminium foil. Now, in the contract, there were a couple of very important clauses. The first one stated that until such time as aluminium were paid in full, ownership in the foil remained with them. The second part stated that when the foil was delivered, it had to be stored separately and identified as being owned by aluminium.
Okay.
And thirdly, if the foil was incorporated into a finished product and sold on, again, until such time as aluminium were paid, they still owned the product. Well, material was sold on, aluminium were not paid, and unfortunately Ramalpa went into receivership. Receiver appointed, obviously had some contact by aluminium, as you would expect, because they hadn't been paid. But the receiver took the line that aluminium were just an unsecured creditor like everybody else, and all they'd get would be the usual 2p in the pound. But aluminium dug their heels and said, no, that clause entitles us to either have our materials back, or if you've sold them, for you to report back to us, paying us the full amount that you've received for the sale of the product. And the court agreed with aluminium and said that's absolutely right. The purpose of that clause was to retain ownership. If the goods are paid for and sold, then you must pay the money back to aluminium.
Okay, so and essentially this is about ownership then. So how does this apply to the construction industry then?
Well, this happens quite a lot in the construction industry as well, because you may well have a supplier or a subcontractor who supplies goods to the site. The architect certifies a payment which will include the goods which are supplied to the site. The employer pays the main contractor. The main contractor doesn't pay the subcontractor, so we've got a problem. So subcontractors protect themselves and suppliers by including in their terms of trading, if they can, a clause that says until such time as we've been paid, we don't transfer ownership to the main contractor, which means the main contractor can't transfer ownership to the employer, which means the employer often has to pay a second time.
Okay, and I suppose in the current economic conditions, this sort of clause is going to have a new lease of life, isn't it?
Well, it is really. We had a similar situation in the late 80s and early 90s when we had a recession which ran on for 6 years, and this happened more and more. And so I think people have to try and guard themselves as much as they can to this situation which could well arise.
Just to reiterate, Deborah mentioned there was a clause named after this. What exactly is the clause and what does it do?
Well, it's a retention of title clause which, as I've already indicates until such time as the goods are paid for in full, you don't transfer the ownership. And it's known as a Romalpa clause because the case involved a company called Romalpa.
Romalpa, easy to remember.
Yes.
Is it in anybody's interest, though, for the clause not to be there?
Well, it's in the employer's interest to make sure the clause isn't there because it's the employer who pays the main contractor. The main contractor then goes out of business. The employer wants to finish off the work using somebody else, but the supplier who hasn't been paid say, well, you can't use my materials because I still own them because I haven't received payment.
Yeah.
So it's a bad clause from the employer's point of view who can finish up paying twice.
Could you just run us through a possible scenario on, say, a medium-sized construction job?
Well, let's say we had an office block and the architect had designed timber windows to be fixed into the office block. And the job is getting underway. We're getting up to floor slab level, and that's about the time when the first payment is due. So the architect issues a certificate which includes the value of work constructed to date, plus the value of the windows which are supplied to the site and stored on the site, not fixed yet, you see. So the employer will pay the main contractor, and main contractor goes out of business. The window manufacturer hasn't been paid. If he's got a clause in his terms of trading which says, I don't pass ownership until I've been paid, he can then say to the employee, if you want to use my windows to finish off the job, you're going to have to pay me. The employee may finish up paying a second time. Obviously not very good news from the employee's point of view.
No. Okay, thank you. And are there any other cases based on a similar scenario that we should be aware of?
Well, there was a case involving Humberside County Council and Dorber Williamson. They were building a school, and Dorber Williamson were the subcontractors who were supplying and fixing the roof slates. The roof slates were delivered to site and were standing on the site ready to be erected. A certificate was issued by the architect for payment. The employer paid the main contractor, but the main contractor didn't pay the subcontractor. So the subcontractor said, well, I've got a retention of title clause, a Romalpa clause in my terms of trading. If you want to use the slates, Mr. Employer, then you're going to have to pay me again. The employer said, he thought he got the trump card here. He said, look, he said, in my contract with the main contract, it says that once I've paid for the materials, ownership passes from the contractor to me. So you've got a conflict, haven't you?
Yeah.
And which one won? Well, the court said, until ownership is passed from the subcontractor to the main contractor doesn't own them. If he doesn't own them, he can't pass ownership on to the employer. So the subcontractor won the case because he never transferred the ownership because he hadn't been paid. So again, the poor employer finished up paying twice.
Well, Butler Machine Tool Company and Excello Corporation in 1979 was also heard at the Court of Appeal. Again, not a pure construction case, but it is the root of a phrase that many of you will be very familiar with. The Battle of the Forms.
Well, Roger, take us through this case then.
Well, Butler quoted Excello Corporation to supply machine tools. Now, the intention was to deliver them some 10 or 11 months after the date of the quotation. It was during a period of high inflation, so they included the clause in their quotation that said, if the price has gone up between the date of the quote and date of delivery, then we reserved the right to increase the price. It was a price fluctuating clause. The quote was received by XLO. They didn't like that very much. They liked the price, which was 75,000. So they sent an order which stated that we're placing an order for your machine tools in the sum of 75,000, which is a fixed price. So you've got a conflict between the quote, which was fluctuating, and the order, which was a fixed price. Now, at the bottom of the order was a little tear-off slip, referred to as an acknowledgement of order, which said, we hereby acknowledge receipt of the order and we agree to be bound by the conditions referred to therein. So the acknowledgement tied up with the order. So Butler received this and read all this, you see, and realised there's a bit of a problem. But nonetheless, they wanted the job, didn't they? So they signed the tear-off slip, which said we acknowledge receipt of the order and agree to be bound by the conditions referred to therein. But then sent a letter to go with it that said, please find enclosed acknowledgement, but please note we'll be supplying strictly on a fluctuating price basis. So you'd got the quote, which was fluctuating, you got the order, which was fixed, you got the acknowledgement, which was fixed, and you got the letter, which was fluctuating.
Right.
So, of course, it's a battle of the forms, and who wins the battle is very key. In this case, XLO Corporation won the battle.
So it gets even more exciting with the battle of the forms then. How does this apply to the construction industry specifically?
Well, you get a situation where a subcontractor, and this is perhaps more common than anything else, will quote based upon certain terms and conditions, maybe those of his own. That will go in the quote. The main contractor will see this, he won't agree with that, so he will send an order based on his own terms and conditions or some standard conditions which are very favourable to contractors. So you've got two conflicting documents. They both are aware of this. They're jockeying for positions, writing to each other saying your conditions don't apply, my conditions apply, but they're under pressure to start. So they start the job then without agreement having been reached. So the court then has to see which is the last shot. The guy that gets the last shot in normally wins the case.
And why did XLO win then?
Well, they won for the following reasons. The court said that the quotation was an offer. And for a contract to come into being, you need an unambiguous offer and an unconditional acceptance. There was no ambiguity about the quote, which was the offer. Now, when the order was placed, that wasn't an unconditional acceptance. It was an acceptance of the price with a condition attached. And that formed a counter-offer, which killed off the offer. So when that was received by Butler and they signed the acknowledgement, which was an acceptance of the counter-offer, then it was game, set and match for XLO. You might say, what about the letter? Well, that was a bit inconvenient. So the court said, we can ignore the letter, that's no relevance whatsoever. So that's why XLO won the case.
Okay. And how far back was this? How
Are we talking a long time
A long
now?
time back. So are there any more recent cases then that
Yeah, there was
are relevant to
case
this
last
battle?
year, in fact,
Yeah.
involving a company called Yates and a company called Gleeson. Gleeson were the main contractors, and a quotation was submitted by the subcontractor for drilling into the ground. And in the quote he said that the FCEC Blue Form subcontract conditions will apply. Well, Gleeson, the main contractor, received this quotation. They didn't agree with the FCEC Blue Form conditions, so they placed an order based upon the IChemE Brown Form. Now, the significance of this is that under the FCEC Blue Form, if ground conditions are encountered which couldn't reasonably have been foreseen and additional cost is incurred, the subcontractor is entitled to be paid more. But that entitlement is not incorporated into the Brown Book. And they both realised this. But as life happens, bad ground conditions were encountered, and the subcontractor submitted his claim because that was in accordance with the FCEC Blue Form. It was rejected by Gleeson because they said, well, the Brown Book applies and you can't claim under the Brown Book. There'd been a lot of exchange of correspondence, and again the court had to decide who fired the last shot. They decided the last shot had been fired by the main contractor, and therefore the poor old subcontractor hadn't priced for the ground conditions. He encounters the ground conditions, additional cost incurred, it gets paid nothing.
Yeah.
Our final case is British Steel Corporation and Cleveland Bridge and Engineering 1984. The case centres on the fact that many projects commence on site before a contract has been signed.
Well, Roger, over to you again. What are the main points in this case?
Well, two well-known firms, British Steel, now known as Chorus, owned by an Indian company, and Cleveland Bridge, who built the iconic arch that goes over the Wembley Stadium. There's a dispute on that as well, but we're not going to deal with that, are we? We're going back to the case involving British Steel and Cleveland Bridge. Cleveland Bridge wanted to build a bank. They'd contract to build a bank in Saudi Arabia. They wanted British Steel to supply the steel, so British Steel submitted a quotation. It wasn't accepted for all sorts of reasons, but Cleveland Bridge wanted British Steel to get on and start delivering the steel. So they sent what was referred to as a letter of intent. And this letter of intent stated that we've got your quote, we'll be placing an order in due course, but in the meantime, will you commence delivering the steel? A few days later, they sent a fax and said, further to our letter of intent, please find enclosed a delivery schedule indicating the dates when we want you to deliver the steel. Fine. The steel starts to be delivered, but no order was ever placed. It just went up an alley somewhere. All the steel was delivered. British Steel submitted a final quotation, final price of £222,000. And Cleveland Bridge didn't pay. They said, we're not paying because you didn't meet the delivery dates included in the delivery schedule. And we've incurred substantial additional costs. And they sent a bill for £860,000 and said, if you send us a cheque for the difference, we'll call the matter closed.
Right.
Well, obviously no cheque was forthcoming, and the court had to decide whether the counterclaim succeeded or not. And they said, well, a bit of a problem here, we don't have a contract. No contract was ever entered into, but we have an instruction given to British Steel to deliver steel, which is what they've done. Therefore, they're entitled to a fair price for delivering the steel. What about the counterclaim? Well, they said there was no contract. So this delivery schedule was non-contractual because there was no contract to which it could form a part. So the counterclaim failed because there was no contractual obligation to deliver in accordance with the timescale on the delivery schedule. So in that case, British Steel won the case and Cleveland Bridge lost.
Okay, but isn't it the case, though, that many projects actually start without people securing contracts?
Yeah, well, the golden rule, a lot of golden rules never get followed. The golden rule is you don't start until you've got a contract. But of course, there are commercial pressures, aren't there?
Yes, absolutely, because I mean, presumably that means that architects and contractors putting themselves in an invidious situation, aren't they?
Well, they do it in a way, but they're under pressure from the employer to get the job finished. And why the contract isn't signed? Many reasons, lawyers perhaps on holiday, or the admin's broken down, or often there are some minor matters still to be agreed. So the contractor on his side thinks, well, I've got a commitment, whereas before I got the letter of intent, I'd got no, I'll get started and sort out the problems later. So I think it's the commercial pressure. And the legal side obviously would be to get the contract signed, but more and more jobs start on the issue of a letter of intent. It's become part of the norm now.
What are the main points that arise from this case?
Well, I think the main points that arise from this case is that you can't get rid of letters of intent. What you've got to do is to make the letter of intent very comprehensive. You could, for example, say, this is a letter of intent. We want you to do the work. It will be in accordance with the JCT 2005 conditions of contract. The start date will be, the completion date will be, the liquidated damage will be. So in essence, all the contractual matters are covered in the letter of intent. And it overcomes, in a way, the delay caused when the contract isn't signed for a long time.
Yeah. Okay, well, we'll have to leave it there. But Roger, many thanks for joining us.
Thank you very much.
Unfortunately, that is all we have time for, but be sure to join us for the third in our series of classic case law. And I'm also delighted to say with Roger. But for now, thank you, Roger, and goodbye.